Hey there, it's Rob Ryder, and it's Monday, June 27th, 2022. And today I'm going to talk about uniform law citations a little bit, kind of follow up to my last video, and then talk a little bit about the Ohio's mayor's courts, which I hadn't realized until recently existed. But apparently Ohio and I think it's Utah are like the only two states that have mayor's courts. And so even like a village mayor can have a mayor's court. And so, if you're involved in a traffic ticket situation in the municipal court or county court or the common pleas court, whatever they call it in Ohio, before, somebody who hasn't really taken the proper oath of office, as we'll look at when we get into this, not only the oath of office, they don't have the governor's commission. That's the big thing. Forget the oath for a minute. I've talked about that enough. They don't have a governor's commission, which is clearly stated that they have to have. Well, then, they're impersonating an officer. And that's something that the Ohio mayor's court would have jurisdiction over. So more on that in a bit. And I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder. My email address is courtofrecord@aol.com. It's really the best way to get a hold of me. If you leave a comment on the videos, I really can't answer them. I've tried a few times to answer people's comments on videos, and both the answer and the question disappear. So yeah, I'm being shadow banned or whatever you want to call it, but still, it's the best way. I mean, YouTube is by far the best way to get a hold of people in this format. So I continue to do so. So again, I want to talk about uniform law citations, and it's really a follow-up to the last video I did, which was traffic citations, dirty little secrets exposed, because a citation has two sides to it. It's got the side you see, and then it's got the back. And you see one of the backs, but as it turns out, this is a multi-page form. Some go to the court, and some go to the defendant. And, the backs are different. So we're going to talk about that in just a second. Hang on. Okay, so, this is what we're talking about. It's called the State of Michigan Uniform Law Citation. Every state's going to have some version of this, right? It's, what we would also call a traffic ticket. That was given to Nate, and, this is what they gave Nate. If you start looking at it, and you look at it has all these blanks in it that haven't been filled out. And they don't have an NA, like not applicable. So, technically this form isn't filled out properly just because of that. Right? You're not going to leave blanks on something you're going to charge me with. I want every blank filled out. If it's not applicable, then they should have an NA in it. But, they pick and choose which ones to fill out, and then they act like they're charging you with these charge numbers, but they never properly cite any Michigan compiled law or ordinance or PAC code, whatever a PACC code is, on these, right? And so really they're charging you for these words. No operator's license, multiple ops, right? If you were to go to court, that's what they would say that you were being charged with. They wouldn't say violation of Michigan compiled law 257.301, no operator's license, multiple ops, right? That would be defining exactly what it was. It'd be the nature and cause, and they don't want to do that. So instead, they put these charge numbers. And you say, okay, well, does that correspond to these numbers down here, which just have these 4-digit codes, which isn't a local ordinance? And if you want to know if it was or not, well, you would go to, where was the thing issued from? Well, first of all, this one couldn't be because this was issued by the state police. So they can't enforce local ordinances. They're supposed to enforce the state law. And I showed in my video last week that on a document like this, that if it's a misdemeanor, which all these are, that has a jail time greater than 93 days, it cannot be done on a citation like this. That a sworn complaint has to have been filed by the person charging you with the violation of the misdemeanor. Well, if this middle one here, 500.3102, was a Michigan compiled law properly cited, then it goes to the Michigan's insurance code that says, violation of this statute, that number, has a jail time of up to 1 year. Well, then it can't be charged in this document. So, maybe it's on here, because there it is, but where is the sworn complaint that goes with it? Because it's greater than 93 days. And again, that's covered in the citation in the Michigan Vehicle Code. It says, these can only be used for misdemeanors up to 93 days jail time. It goes on, and it had the 72nd District Court, Marine City, and Michigan only has one district court according to the Michigan legislature, so it can't have 72 or more, right? And I showed that if you take this phone number and you put it into Dun and Bradstreet to do a search to see if they have a Dun and Bradstreet number, you find out that it's not, the 72nd District Court that comes up. It's the judiciary court system of state of Michigan or something like that. But it's not the district court, right? It's a business with that name. And, it goes on and on. There's just all sorts of things wrong here. Like, this is no man's name or no man's signature, right? Ray Peckman isn't somebody's full legal name. So, anyways, this is what they give you. And, this has a back to it, right? And it's called, in this case, it was called the misdemeanor side. Okay, so let's go read a little bit in the Vehicle Code again about these citations, right? That a citation, first of all, it's issued to each, I'll just read it. Each police chief, including state police, issues a citation book to each police officer in the department who has law enforcement duties. Each police chief shall obtain a receipt from the officer to whom the citation book has been issued upon a form created by the Secretary of State, Okay? So you have to sign for this book on a form that was created by the Secretary of State, the Attorney General, the State Court Administrator, and the Director of the Department of Police. Those 4 people are responsible for the citations or the receipt of the citation. But you'll see in the next one, well, they're responsible for the citation too. Because on a form determined by the Secretary of State, Attorney General, State Court Administrator, Director of the Department of State Police. Right? The original, which shall be a complaint or notice to appear by the officer and shall be filed with the court on which appearance is to be made. The first copy, which shall be retained by the local traffic enforcement agency. The second copy, which shall be delivered to the alleged violator. And the third copy, which shall be delivered to the alleged violator if it's a civil infraction. So you get one if it's a misdemeanor. You get a different one if it's a civil infraction. Because on the back, they have different things on them. Right? But the original is supposed to be filed with the court. Okay. Okay, so then elsewhere it talks about, failure to answer a citation or notice to appear in court. Well, what does it do to you? Well, in this section, 321A, right, it says a person who fails to answer a citation or notice to appear in court for a violation reportable to the Secretary of State under 732 or local ordinance substantially corresponding to the violation of law of this state reported to the Secretary of State, or for any matter pending who fails to comply with an order or judgment of the court, blah, 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 is guilty of a misdemeanor, punishable by imprisonment not more than 93 days, or a fine not more than $100 or both. All right, so obviously it's important to answer the citation. And in another section then, it talks about a civil infraction defined. And then one of them, what is a civil infraction determination? It's a default judgment for failing to appear as directed by a citation or other notice as scheduled for appearance under 745 3B or 4, blah, 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 blah. Right? So it's a misdemeanor. It's a default judgment for failure to appear. And, well, that's contempt of court. Right? Now, what's a civil infraction? It means an act or omission prohibited by law, which is not a crime as defined in Section 5 of this is the penal code they're talking about. No, you know what a civil infraction is? It's not a crime. It's a sin. Or you didn't break any laws, but you violated some, some unknown religion's definition of a sin. Right? That would be those Talmudic law courts, which, in the 7 Noahide laws, one of the laws is to establish courts of justice. And in the Michigan Constitution, it says there shall be one court of justice. Right? Well, that would be a Jew court. And I'm not a Jew. Thank you very much. They're not Jews either. They're false Jews. Right? They're not Old Testament Jews. Old Testament Jews knew their lineage all the way back to Adam through their fathers, and it was all written in books kept in the temple. Well, between Herod and the Romans, they destroyed all those books. So now the people who claim to be Jews are really just Jewish. They wish they were Jews, but they're not Jews because they don't know who their daddy is. Right? They claim to get their Jew through their mother, which is completely opposite to what it was in the Old Testament. And yet these people say, well, we're going to get to enforce the Noahide laws, and, that's not good for Christians. So we need to, put an end to their belligerence. And it's starting to happen, right? That the people who wish they were Jews say that abortion is part of their religion. Well, that's good to know. I mean, they never said that before, but now that's come out in this public news. So, the devil system is already falling apart. We just got to keep pushing on it. Okay, so if you look hard enough online and Google like State of Michigan Uniform Law Citation, eventually you can find what one of these looks like, right? Now, where it talked about there being 3 copies, or there being original, the one that goes to the court, and then 3 copies, one for the police, and then either a misdemeanor or a civil infraction one to go to the defendant. And, darn it, hang on. Okay, so this isn't the latest revision of this document, because this one on here has a place to put your social security number, and that was one of the last things to be changed on the document, was getting rid of the social security number. Because they used to leave this blank, right? They put your full legal name in and they leave social security number blank. Well, how, which Robert Allen Ratluski are you speaking of? Because your social security number is the thing that authenticates your name. But nevertheless, this is a 6-page document where we've got sheet 1, 2, 3. Right, this side all looks the same. 4, 5, 6. Then we get to the back side, right? So this would be like the back side of sheet 1. And this is where, the meat and potatoes are, because this is the District Court Register of Actions. And if you were to read enough in Michigan's clerk manuals and so forth, you would find out that the Register of Actions is the official record of the court. Right? Not what they put on the docket, not anything else. No, the official record of the court is the Register of Actions. Okay, and it says District Court Register of Actions. Now, on the front, it said 72nd District Court. Right? If we go and look at, the one that our victim got. Excuse me. I don't know why that's way down there in the end. This over here. Right? District Court Register of Actions. And this thing here says 72nd District Court. Well, This doesn't say 72nd District Court, it just says District Court, right? Which is proper because there's only one District Court. They're supposed to have the violation, the date, the case number, right? Personal recognizance, what kind of bond, appearance date supposed to be on here. I mean, this is all stuff you need to know. And we'll go back and look. The police chief is supposed to have sent this within 3 days to the court. Right? So from the date that you get the ticket, within 3 days, they're supposed to send it to the court. Now, we look at this thing, right? Whenever you go to court, they'll only ever say guilty or not guilty. But look at your other choices, right? If you deny, like in an informal hearing, if you deny the charges, then whatever has been stated on the front has to be sworn to on a sworn complaint and filed with the court, right? They can't use the citation anymore. It's only presumed to be done under oath because of the penalty of perjury statement on the front. All right, I declare the penalty of perjury. So because that's on there for within the allowances of the Michigan Vehicle Code, this is considered sworn to. But if you deny the charges, deny, right? Well, now they have to have sworn complaints. So that's, really important because all they ever say is guilty or not guilty. And people say whatever they're going to say. Well, what you should be saying is you deny. Because once you deny, now they have to swear to it. Okay, and if they don't swear under their full legal name, well, that's what you point out. Say, I want to see the man's driver's license, operator's permit, state ID, whatever it is that has their full legal name on it, right, to make sure that's the person that's charging you. Because this dude here, this Ray Pickman, he doesn't exist. There's no birth certificate in that name. And that's where your full legal name comes from. Unless you actually go to probate court and do an official name change, your legal name is the name on your birth record. Okay, and then it goes down and say, here's the actions and the case notes. So this document has to be filed with the court, right? This is a court document. And because it's a register of actions, that's considered a document that's available to the public. So they have to give it to you. And, so if you're in Michigan and you have a case going on, you need to go down to your district court, whatever one you're going to, and tell them you want to see the documents or the citation, the court copy of the citation sent to the court. Now, like I said, there's 3 of these, right? There's one. Here's another one. So there's actually 3 of these, right? So I, just last week, I sent a request to the, here it is, to the Rockford Department of Public Safety, saying that this particular MCL requires the police chief to deposit citations in the court by United States government mail. Somebody said that's certified mail. I mean, I don't know if it is. Where does it say that? Don't just tell me. Show me the citation that says certified mail is government mail. If it is, I'll believe you. Right? All I know is this says United States government mail. I say that means, okay, it has to be in an envelope that says this is official business. Have a little sticker up in the right-hand corner, right, to show that it's going through, it's like franked mail or something, right? It's got doesn't have to have a stamp on it. Please provide the name of the court and address a police chief addresses to the United States government mail envelope. And so they approved it, and they said they put on here 63rd District Court, which is, my version of this court right here. But, well, there's 3 copies. What about the other 2 copies? Here's where it says it, right? This is 257-728A, citation delivery of copies to the police chief, right? At or before the completion of his duty, whom a citation book has been issued. and who has recorded the occurrence of a vehicle law violation or upon a citation shall deliver to his chief or person duly authorized by the chief to receive citations all copies of such citations duly signed. The police chief or the person duly authorized shall deposit the original of the citation with the court having jurisdiction over the offense with no later than 3 days after citation, excluding weekends, holidays, 3 business days. That's easy enough to understand. Okay, so the citation has been considered to have been deposited with the court as required under Section 1 if the original of the citation is mailed not later than 2 days after the date of the citation as specified under the section. Well, that'd be within 3 business days. Mailing shall be accomplished by enclosing the original citation in a sealed envelope, first-class postage, fully prepaid, addressed to the court, deposited in the envelope and contents, of the United States government mail. Right? So fully paid, prepaid postage, That's when they put that stamp up in the upper left-hand corner. They don't use a postage stamp. Right? They use their franked mail stamp. So the original was supposed to go to the court. Then what's happening to the other copies that say that they're court copies? Because there's 3 of them altogether. Then here's one that goes to the police enforcement agency. We talked about that first copy, right? That's where that one goes. Then you have a misdemeanor one, and then you have a civil infraction. Right? Those are all our choices. Right? MCL 257-727C, citation defined. Right? The form had to be determined. So did the Secretary of State, the Attorney General, the Court Administrator, the Director of the Department of State Police, did they authorize these people to make, 3 court copies and put it together and call it a uniform law citation? Is that what they intended? Or is this whole form just something that's been made up by the Esquires and the fictitious United States of America, state of Michigan jurisdiction, and they're just simulating a legal process, right? Which would be a violation of your civil rights. The original shall be filed with the court in which the appearance is to be made. The first copy retained by local traffic. Okay, well, I got that. Second copy is a misdemeanor. Yep. And third copy is an infraction. Oh, yep. That's what, this makes it look like. Excuse me. Civil infraction, misdemeanor, police force enforcement. Okay, well, that'd be our 3 copies, and then these are supposed to be the original. Well, why are there 3 of them? We're sending it to more than one court? Because I've shown before, if you go to federal court, if you go look at the docket on Pacer for somebody's case, like I showed the latest one with Steve Bannon, which, if you want to see it, is in a video I did. That's, where is that at? LT Steve Bannon, Fire Your Cannon at Esquires. And you will see that on the docket, it shows that he's being charged twice for the same crime in 2 different courts. There's 2 cases been opened for his contempt of not, showing up for the fake Congress's subpoena. Right? And it went to 2 different courts. So, there being 3 citations in Michigan, it's okay. Well, you sending one to 3 different courts, and I'm not going to the right court. I went to the fictitious court instead of the proper court, because this is for the district court register of actions, not the 72nd district court or the 63rd district court or any other number district court. There's only one district court in Michigan. And so, if they made 3 copies, they need to account for all 3 of them. And, because the Secretary of State and so forth have something to do with this, later on I'll be contacting them and say, hey, did you authorize this to be made in triplicate? And, see what they have to say. But I'm just pointing out the things that are wrong. So findings, you got responsible, not responsible, default, guilty, not guilty, as charged, no lay, prosecute, or prosecutee, right? Where basically check, box, not responsible. If it was the proper court, that's the answer I want. If it's not the proper court, I don't want them to have a damn thing to do with it. So, if you're in Michigan and you have, a traffic case going on, would you please go down to your court and find this thing, right? Tell them you want a copy of it and, have it sent back to you. Send me a copy. courtofrecord@aol.com. I want to see what the back of one of these looks like. Or I want to see what the multiple backs of these look like. Alrighty, just a couple other details, right? The devil's in the details, so it's good to go over them a few times. That now that we know what the form is and what the first copy is and what the original is, second, third copies, well, then we find out, we keep going down here, that with prior approval, the state officials enumerated in Section 1, the Secretary of State, Attorney General, State Court Administrator, Director of the Michigan State Police, appropriately modified as to content numbers of copies to accommodate law enforcement and local court procedures and practices. Right? So, okay, well, did they or didn't they? That's what they need to tell us now. Did they actually do that? And then for the purposes of this act, which is the Michigan Vehicle Code, a complaint signed by a police officer shall be treated as made under oath if the violation alleged in the complaint is either a civil infraction or misdemeanor ordinance for which the maximum permissible penalty does not exceed 93 days in jail or both. Occurred or was committed signing presence under circumstance permitted, and if the complaint contains the following statement immediately above the signature of the officer: I declare under penalty of perjury, Well, unfortunately, for this Ray Peckman, right, he put on one that had greater than 93 days. So it can't be used for that. And then finally, admission or denials, right? If the person denies responsibility for a civil infraction, further proceedings shall not be had until a sworn complaint is filed with the court. Now, in Nate's case, he doesn't have any of those. He doesn't have civil infractions. He has misdemeanors. But a lot of times it says civil infraction on there instead. So if you deny it, well, then then they have to stop and they have to file a sworn complaint. Shall not be had until a sworn complaint is filed with the court. A warrant for arrest under 321A failure to appear for civil infraction shall not be issued until a sworn complaint relative to the civil infraction is filed in the court. Okay, so if you don't go, they're not supposed to arrest you. Like the second time they pick you up, they check the record. Oh, hey, you didn't show up for court last time. Right? Now they're going to arrest you for that. But if that's the case, well, where's the sworn complaint for the civil infraction that you apparently allegedly violated in the first place? Well, all that stuff is supposed to be in the Register of Actions. And so this is for the, happens to be for the district we're talking about, the 72nd Judicial District, access, inspection, reproduction of court records, where it says this is under Michigan Court Rule 81119H and 810C7. The clerk may not permit any case record to be taken from the court without an order of the court. The court may provide access to public information in the Register of Actions through publicly accessible website. However, all other public information in its case records may be provided through electronic means only upon request. So you have to specifically request the information. Court records addressed by administrative order include records kept by the clerk of the court, includes case files, Register of Actions, right? Well, that's what we're talking about. What's in the case file? What's on the Register of Actions? Because the Register of Actions is actually on the on the back of the damn form. Right? District Court Register of Actions. This form right here. It's supposed to have everything they did listed in here. That's why we need to see one, people. So, if you got one, If you go down to your court, say, hey, I got, you have the other side of it. You know what it looks like, right? Say the court was supposed to have been sent these, the court copy of this. You would like to have a copy, but you want to make sure they give you a copy of the back. Because they only give you a copy of the front, right? You're not going to see this. Because the fronts all look the same on all of them. Okie dokie. Well, let's talk about the Ohio's mayor's courts. This is really just an introduction as I learned more of it myself, but there's a couple of people that have things going on in Ohio, and I'm hoping that we can get them to, go check this out and find out what it's all about. So, hang on a second. Okay, so again, there's only a couple states that have mayor's courts. Apparently, that's what they said here in Ohio, and I think it's Utah. But because they do, let's talk about it. So in Ohio, then you got the Supreme Court, your Court of Appeals, you got your Court of Common Pleas, right? In each of the 88 counties, you got municipal and county courts, got a Court of Claims, and then, hey, down here at the bottom, a mayor's court, right? It's not courts of record, violations of local ordinances and state traffic laws. Matters can be heard in municipal or county courts. Reheard, okay? But violations of local ordinances. All right, so in this particular city we're talking about, which is the city of Medina, but kind of find out this is the exact same in the city of Zanesville, so it's probably the exact same in a lot of states or a lot of cities, right? If you were to go and do a search like on hang on now. City of Medina Muni Code. Almost every city anymore, they have their Muni codes online, right? If you I don't know what's going on here, but it's taking a little bit of time. Okay, City of Medina, codified ordinances. That's close enough. The City of Medina, Ohio. That's the place we're talking about. The internet's a bit slow today. Must be a war going on. Okay, yes, click here. Yes. Fine, I'll click here. Okay, so then, well, here we are, Medina, Ohio. And then we got these different sections here where it says Part 5, General Offense Code. Well, since I know that's where it is, let's go take a look. And in the General Offense Code, they have all these kinds of offenses. Railroads, weapons, theft, fraud, property offenses, offenses against persons, obscenity, liquor control, law enforcement, and public office. Hey, let's look at that. And then you'll find, well, they have this whole thing about, public office, law enforcement, and public office. So that's where this came from. And in here, you have a lot of, definitions that you can use to your advantage. But then we talk about falsification. A person shall not knowingly make false statements, knowingly swear or affirm to the truth of a false statement. Right? A statement, when the following applies, statements made in official proceeding. Yada, yada, yada. Okay, we could, probably pick something out of there to complain about. But I'm going to pick this, impersonation of a peace officer. Because a peace officer means sheriff, deputy marshal, member of organized police, municipal corporation, township constable, who's employed by a political subdivision of the state, members of the police force employed by Metropolitan Housing Authority. Lots of different people who call themselves a police. And then we get on to an officer, agent, employee of the state, or any of its agencies, instrumentalities, or political subdivisions upon whom, by statute, a duty to conserve the peace or to enforce all or certain laws is imposed and the authority to arrest violators is confirmed. Well, we would be talking then about the prosecutor and the judge. They fit that jurisdiction or that definition, right? So if you're in any kind of court case in Ohio, right, there's going to be somebody who's the prosecutor and somebody who's the judge. Well, if they didn't do things right, then they're impersonating a peace officer, which is a local ordinance violation, and you could take them to the mayor's court for that. Because the court the building they're holding the hearing in is within the city limits of some city. Now, the other thing is, this applies to village mayors also. So if you're getting mail sent to you from one of these courts, well, now they're using the mails, right? So now it's happening in the jurisdiction of the mayor of your municipality. So they could hold the court. That's, again, it's my belief. If we could find one patriotic village mayor in Ohio that would test the system, we would find out. But they got to be faith-filled and ready to go because playtime is over. Right? You should be able to file, as we'll see, a criminal complaint with the mayor's court, and they got to deal with it. I'm just saying, well, because the judge in your traffic case or your, whatever case, civil case, foreclosure case, criminal case, whatever it is, sitting over there in what we would believe is the county court in Ohio or the court of common pleas or whatever it is, then people have to have this. If they don't have it, well, they have to be qualified. If they're not qualified, well, then they're impersonating a peace officer. So how do we tell if they're qualified? Well, I keep talking about the judge's oath because, that's the one thing. But something that they had in Ohio. So if you're in Ohio, you might want to take a minute right now and just pause for a second and write down this title so you can go Google it. Right? Statutory requirements before commencing judicial service for an elected or appointed judges. Well, that may be really freaking important, right? The step-by-step guide, the 1, 2, 3 that it takes for that person sitting there in the robe to be a judicial officer. And if he isn't done the 1, 2, 3, well, then he's impersonating a peace officer, under local ordinances. So, file a fucking complaint. So what do you have to do, right? The Ohio Revised Code directs the preparation of 2 documents relative to your election or appointment. A certificate of election or appointment and a governor's commission. Governor's commission. Governor's commission. You must have both a certificate and commission before you take the oath to begin performing judicial duties. Okay, so now they're going to give you a piece of paper and say it's their oath. And when you look at it, they're wrong because they don't use their full legal name and they make grammatical changes. They do all sorts of shit that's wrong. Okay, so it's really not an oath of office. So before they could get to that point, though, to even take the oath of office, they had to have these other things. So go to number 1 and number 2 before you go to number 3. And so number 1 is, following your election or appointment, a certificate of election or appointment as applicable is issued by one of the following entities. For the Supreme Court comes Secretary of State. Appellate judge whose district consists of more than one county, the County Board of Elections. For all other judges, the County Board of Elections. So either it comes from the Secretary of State or the County Board of Elections. Right after the certificate of election or appointment is issued, and you pay the required $5 or $2 fee for county court judge, right? The Board of Elections forwards the certificate and fee to the Secretary of State. Well, where's the receipt that they did that? Because we're talking about public monies. And did they send 5 or did they send 2? Did the judge, give them 5 or give them 2? Has he done that yet? Because that's what gets the certificate of election forwarded to the Secretary of State. And then once the Secretary of State receives the certificate of election or appointment and fee, a commission for the governor's signature is prepared. The Secretary of State then transmits the signed governor's commission to the clerk of the Court of Common Pleas of the county in which you reside. Upon receipt of the commission, the clerk transmits the commission to you. So, where's the record that it went through the clerk's office? Because the commission, is eventually supposed to go to the person. Now, this is right out of Marbury versus Madison, which was, 1803 or whatever it is, where they keep talking about that being the, basis of judicial review. But what it really was the basis of is, if you don't have a commission, you don't hold the office. Because the outgoing president had prepared all these commissions and signed them, but he hadn't delivered them. And so the incoming president didn't issue them. And so the people that they were supposed to go to, didn't hold the office. And so if they don't have a commission, they don't have a governor's commission, then they're not a judge. Or they're not a prosecutor. Because I'm saying this applies to all of them. I know it applies to judges, but I'm going to assume it applies to prosecutors also. But nevertheless, a prosecutor is a law enforcement officer, and so in that respect, he has to have it also. So let's go back and look at this real quick. All right, an officer, agent, or employee of the state or any of its agencies, instrumentalities, or political subdivisions upon whom by statute a duty to conserve the peace or enforce all or certain laws is imposed, and the authority to arrest violators is conferred. Okay, well, here in the Ohio Revised Code, section 2931.02, it says a judge of a county court is a conservator of the peace and has jurisdiction in criminal cases throughout his area of jurisdiction. Okay, so at least that judge is a conservator of the peace. Okay, and then if we go and look at general provisions, definitions in section 2901.01, and we go down here to, excuse me, who a law enforcement officer is, right? Because that was the other ones they talked about, was conservator of peace and enforcing the law. Right? Well, of course, you got the sheriff, deputy sheriff, constable, police officer, all the people that you would normally think of. And then the agents, officer, agent, employees of the state and its agencies, instrumentalities, or political subdivisions. Hey, this reads a lot like it came out of the local ordinance. Right? A mayor is the chief conservator of the peace within his municipal corporation. Auxiliary police force. Right? They have the authority then, right? So there's all these people who have some authority to do something in our aid. We need to quit thinking of them as all being against us, right? Not all police officers are against us. Right? Most of them are just doing what they're told. They've never been learned in the law. Right? And they may be looking the other way, but if we can put the fear of God back in them, they'll turn the right direction. A person lawfully called pursuant to something to aid a sheriff, appointed by the mayor, organized militia, a prosecuting attorney, Secret Service officer, municipal prosecutor. All these people are law enforcement officers. And so they're all peace officers. And so if they, haven't complied with the law to be a peace officer by having a proper oath and filling out the proper paperwork and jots and tittles of the law all being done, then they're impersonating a peace officer. Just put the claim in and make them prove that they're not. Right? Because it's failure to report a crime. That's ordinance violation. Then we can go down further and say obstructing justice is obstructing official business, resisting arrest, having unlawful interest in a public contract. I wonder how many of them are guilty of that. Dereliction of duty. No law enforcement officer shall negligently do any of the following: fail to serve lawful warrant, or fail to prevent or halt commission of an offense or apprehend an offender when it is in the law enforcement officer's power to do so. Law enforcement, ministerial, judicial officers negligently failed to perform a lawful duty in a criminal case or proceeding. Interfering with civil rights. No public servant under color of law of public servant's office, employment, or authority shall knowingly deprive, or conspire, or attempt to deprive any person of a constitutional or statutory right. Well, that's what they're doing. If they're not who they say they are, and they're taking you to a court that doesn't really exist, run by esquires in the parallel esquire jurisdiction, United States of America, state of Ohio, United States of America, not Ohio, United States, right? Two different jurisdictions. That's what they're doing to us. Right, Ohio Revised Code, Section 733-24, Mayor of a village. The mayor of a village shall be elected for a term of 4 years, commencing the first day of January next after his election. He shall be an elector of the village and shall have resided in the village for at least 1 year immediately preceding his election. Such mayor shall be the chief conservator of the peace. Well, there you go. He's a peace officer. Ching, ching, ching. Therein it shall have powers and duties provided by law. So he can arrest these people for what they're doing. He doesn't need anybody's permission. He doesn't need the council's permission, the police chief's. He can do it. He's the chief conservator of the peace. Mr. Little Village Mayor, village of 50. It doesn't matter. You're the conservator of the peace. If these lying fucktards are sending mail into this, into your jurisdiction, they're using the mails to commit fraud. Fraud and swindle, they go together. Okay, so, this is for people in Ohio. You're going to have to do this, right? Please do, and bring back some information, court of record at AOL.com, so I can share it with others, right? Because I don't care what, how it gets done. I just want to see it done. So you can find this without too much problem. Google it. The Supreme Court of the state of Ohio is called the Mayor's Court's Bench Book. Wasn't that handy? Right, and if I go to... No, that's not what I wanted. Page 3 of the Mayor's Bench Book. Here's actually page 13. Yeah, complaint and summons for criminal cases. In criminal cases, the complaint must be filed pursuant to Criminal Rule 3. The summons shall order the defendant to appear at the stated time and place and inform the defendant he may be arrested, or they may be arrested if they fail to appear at time and place stated. A copy of the complaint shall be attached to summons, yada, yada, yada. A summons in lieu of a warrant is preferred method of taking a person to court. When an offense carries no jail time, a warrant shall not be issued. It goes on and on and on. But let's go back to what it said, right? If you want to say it's a criminal case, the complaint must be filed pursuant to Criminal Rule number 3. Which I believe is right. If you Google that, it'll take you to this, it's a 148-page book, but Rule 3 is the complaint. The complaint is a written statement of the essential facts constituting the offense charged. It shall also state the numerical designation of the applicable statute or ordinance. It shall be made upon oath before any person authorized by law to administer oaths. Right? A written statement of the essential facts. Sworn to. Oh, hey, that'd be a sworn statement. Now, is it called a witness statement? Prosecuting or plaintiff statement? Prosecuting statement? Prosecuting witnesses statement? What is it called? They call it a complaint. So, right, Rule 3 complaint. Right, so that's all it's supposed to take. All right, so, well, what would you complain about? Right, now you got to figure out what words are going to go on paper to take down and complain. And so I'm just playing around a little bit with it. And it's like, okay, well, blank, whoever it is, the judge, and blank, the prosecutor, are impersonated as peace officers inside the city limits in offense of City Ordinance 525.03, impersonation of peace officer, as part of a scheme to defraud the United States, Ohio, and its inhabitants by impersonating it as constitutionally qualified executive and judicial officers of Ohio. These individuals do not have a governor's commission filed with the clerk of the court of common pleas, and without this commission, they are impersonated as peace officers, and their acts and deeds of their usurpation interfere with civil rights and offense of City Ordinance 525.13. Something like that. But of course, before you can do that, you have to go down and see if these people have a commission, a governor's commission. And, the part I was reading to you from the Supreme Court of Ohio, it only really applies to, judges. But, I'm sure if we were to go look at enough of these other revised codes here, we would see what other officers this applies to, because there's no reason for just a judge to have a certificate of election issued, right, and have to pay the fee. They should be for all elected officers. And so the ones that know, right, that this is right out of the Election Commission. Is that what they say? Is it the Election Commission, or they call it the... Oh, hang on here. All right, the County Board of Elections. If it's anyone other than the Supreme Court, it'd be the Secretary of State, and then everybody else is through the County Board of Elections. Right, so go talk to your County Board of Elections to find out if they issued certificates of election to whomever, right, the prosecuting attorney or whoever it was. And did they forward the certificate and the fee to the Secretary of State? And, where's the proof? Where's the receipt to show that it was done? And now the rest of this, right, once Secretary of State receives a certificate of election or appointment fee, a commission from the governor's signature is prepared. Secretary of State then transmits a signed governor's commission to the clerk of the court of common pleas. So the court or the county in which you reside, upon receipt of the commission, the clerk transmits the commission to you. That'd be number 4. All right, so yeah, we'll just finish up here, right? So according to that section that was at the bottom of the page of the thing we're looking at, where are you? Here you are. 107.06, right? Revised code. Excuse me, 107.06. It says, when the results of election of any officer mentioned in 107.05 is officially known to the Board of Elections of the proper county, upon payment of a fee, right, the board shall immediately forward by mail to the secretary a certificate of election of such officer and such fee. Upon receipt of the certificate and fee by Secretary of State, governor shall issue a commission to the officer for the office named in the certificate, and shall forward the commission to the clerk of the common pleas, who shall deliver the commission to the officer therein. The fees received by the Secretary of State shall be paid into the state treasury to the credit of the General Revenue Fund. So there has to be a receipt someplace. And who were they talking about? 107.05. Let's go look. Judge of a court of record, state officer, county officer, militia officer, judge of the county court, shall be ineligible to perform any duty proceeding to his office until he presents the proper officer a legal certificate of his election or appointment and receives from the governor a commission to fill the office. Judge of the court of record, state officer, county officer, militia officer, or judge of a county court. Okay, well, I say that covers them. You just say, well, they're covered by that. Or you can say, I believe they're covered by that. But for certain, the judge has to have it, whether the prosecutor does or not. You worry about that secondary. But right, it's the prosecutor that brought you to the judge that doesn't have the proper oath of office, so he should be responsible for something. Okay, I'm going to leave it there. You got the gist of it. Uniform Law Citation. They got 3 copies, say court on it, and they're supposed to go to the court. So did they go to 3 different courts? Did one court get 3 copies? What court did they go to? And where's the proof? And go find it, because on the back is the register of actions, and whatever's happened in your citation case, traffic case, whatever you want to call it, right? It's supposed to have been, put into the register of actions. That's the official record of the case. And if you get a copy, please send it to me at courtofrecord@aol.com. All right, more on this stuff later. You all have a great day. We'll see you now.